I got one letter and two words for you to remember. E Jean Carrol. E Jean Carrol, she's about to win for the third time against Donald Trump and inch ever so closer. She's at the 11:58 mark and the clock is about to strike midnight against Donald Trump on a $100 million or two judgments totaling $100 million against Donald Trump for sexually abusing her and defaming her not once but twice. This based on my report of a Second Circuit oral argument about whether Donald Trump had presidential immunity to defame E Jean Carrol. I don't think so. And I don't think you will either after you listen to my breakdown, along with Karen Friedman Agnifilo on Legal AF, the podcast. And here's a clip. But let's turn to somebody who demonstrates that it's necessary, even though there's hard work there to protect our democracy. It's necessary to hold these people accountable and go through a process, file the lawsuits, have the trials, suffer through the appeals by Donald Trump and come out the side victorious. I know you're a big fan, as I am, of everything E Jean Carrol has done to try to reclaim her life as a sex abuse victim. Not my words, the words of two different juries who got to see the case, got to see the evidence. Donald Trump has been trying ever since to rewrite history. While on one hand, he continues to defame her. I know they're considering other lawsuits against him. He's also lost two trials. He's got an $83.5 million judgment in one case about him defaming her when he was president of the United States, and another one for $5.5 million when he defamed her when he wasn't president of the United States. The sex abuse happened when he wasn't even a candidate. So it all goes back to the 90s. And so Donald Trump has tried every which way at the appeals level to avoid paying her the money. Now, to remind people or to tell them for the first time, there is a bond for each of these judgments. So she will be paid eventually, even if Donald Trump refuses to pay her when he has exhausted all of his appeals. He had to post a $5.5 million cash bond. He's got a bonding company for the $83.5 million running with interest. So she'll get paid. He ran to the Second Circuit a number of times. One of them we reported on 2 years ago, where Alina Habba, yes, Alina Habba, went to court to argue that the judgment that the case against Donald Trump related to the $83.5 million should never have gotten off the ground because he enjoyed presidential immunity. And the Second Circuit panel 2 years ago looked her in the eye and said, that's sort of interesting, except you haven't raised that issue in the 18 months of this trial. And you have to raise immunity as a defense. And she said, well, no, you don't. Presidential immunity is unique. You don't have to raise it. It's just automatic. And they did not buy that. And they shot her down. They never took an appeal to the Supreme Court. So for me, it's a conclusive order, law of the case, if you will. Now you fast forward and they decide now that Trump controls the Department of Justice, they'll try a new trick. They'll file a motion with the Second Circuit. This is now in the last several weeks to try to have the United States of America intervene in the case and take Donald Trump out as a defendant. So the case would then be E Jean Carrol versus the United States of America on the argument that he was acting within the course and scope of his duties as president and has what we call Westfall immunity. And why would he do that? Because the next step is the government saying sovereign immunity, you can't collect against us. And the Second Circuit panel, and we did the live audio of the oral argument on Legal AF, said, led by Judge Chen, said no. No, we are not allowing, it's already been up on appeal on this issue. It's not, him defaming her as president of the United States is not part of the course and scope of his duties. We don't find Westfall immunity. We're not going to allow you to intervene. That was just the last several days. Same panel has to hear a new issue. Donald Trump now argues, wait for it, presidential immunity on the same judgment, on the same argument he already raised and lost 2 years ago. Karen, why don't you take it from there, and then I'll give you the wrap on it.
Yeah, so look, they're basically saying the case should be thrown out because of presidential immunity, because that at the time that the statements were made in question, he was president. He says, not only was I president, that it was in we discussed it amongst the White House, and this is in response to a reporter. It was an inquiry about a matter of public interest. So this was part of my presidential authority. And the panel who heard this was essentially skeptical because what they're citing is Trump versus United States, that basically gave him criminal immunity, but didn't say anything about civil immunity. And so the panel was skeptical, basically saying, he may have waived this by not raising it earlier. Of course, the Trump administration says, well, how could we have raised it earlier? Because at the time that we made this appeal, Trump v. United States hadn't been ruled on yet. But look, the issue of immunity and civil immunity was something that has already been settled and has been kind of well settled law, that they are not immune from civil suits for things outside of your presidential duty. That's why Paula Jones was able to sue Bill Clinton while he was president. And of course, it was about something that happened prior to his presidency. But Trump's trying to make I defamed her as part of my job description, as part of my job duties. So we'll see what they say. We'll see what happens. Ultimately, does it matter? Not really, because the audience is the Supreme Court, and so that's where he's going to appeal it to. And let's see what they end up saying. But that's where we are here, and we'll see what ends up happening. And you said earlier, Popok, that she'll get paid no matter what because he posted a bond. Not if the case is reversed, right? Not if the Supreme Court ultimately says, sorry, we do find you immune.
No, I meant if she wins.
If she wins. Exactly. I know. That's why I wanted to clarify that. That's why I just wanted to clarify that the Supreme Court is really unpredictable and very pro-Trump, as we know. And so we'll see what they decide here. I mean, no one in a million years thought they would have said he would get immunity, presidential immunity criminally. So I don't know. All bets are off for civil immunity.
I don't see it on the civil side with the Supreme Court. I'll tell you why. They already raised this issue of presidential immunity. And as you rightly pointed out, the civil immunity, the June 2024 immunity decision, which we talk about in shorthand, was about immunity from criminal prosecution for core presidential functions, constitutional core presidential functions, or those within the scope and course of a president's job description, if you will, stretched to its outer boundaries. And then this third bucket, which is private conduct, is always prosecutable. They never really addressed the civil side. Now, with their argument here, this guy Justin Smith, who argued for Trump, they said, well, why are you here? You raised this issue at the Second Circuit 2 years ago, and you lost on waiver. Why hasn't it been waived? Well, we couldn't have waived because, as you said, Karen, the new decision came out. But the new decision did not change the jurisprudence as it relates to civil liability for non-presidential conduct. But the underpinnings of it, well, okay, but you've waived it. Now, they're going to make the argument ultimately on appeal when they file their writ of certiorari asking for a full-blown appeal on this, because they're not going to get an emergency application on this. On a civil case not involving the U.S. government, this ain't happening. But the court could take it up. He only needs 4 people to be interested, 5 to overturn. But I think they're going to find it a little bit unsavory, given that the conduct that a jury found that he did happened before he was even thinking about running for president. It's sex abuse and defamation with a dollar amount judgment. And it doesn't impinge. And I don't think they're going to be that enthusiastic about revisiting the wet cement of the immunity decision from a year ago. If John Roberts doesn't have to type out the word immunity for a president ever again, I think it will be too soon. I just don't see them wanting to do that again. Although they want to help Trump, the guy named Trump, as opposed to the presidency as an institution. So they'll try. I think they have. I think it's been waived. I don't think there's anything about the immunity decision that helps revive the claim. And the only remaining argument is the one that Alina Habba made without any case law, and that was shot down 2 years ago, which is you can't waive presidential immunity. Remember the panel at the time was like, sorry, you can't waive it. It's unwaivable. Well, why is it unwaivable? It has to do with the institution of the presidency. But it's a privilege. It's an immunity, right? Yes. So all immunities, and then they cite all the case law, all immunities can be waived by conduct or action or otherwise. Suppose the president wanted to fight this off because he wanted, or the candidate or whatever, wanted to have the American people, have the evidence heard in public. He'd been charged in public. He'd been accused in public, had a judgment against him in public. Maybe he wanted to clear his name. Couldn't you envision? I remember them saying to Alina Hava, can't you envision a president who wants to clear his name in a courtroom? And she was like, no, because that's not Donald Trump. It's the opposite of Donald Trump. So I think they lose on waiver. I think this is you can't wait 2 years into a case to raise the issue. And it doesn't get revived because later on, a better Supreme Court decision on the issue comes out, pardon me. So, and if to be rounded out, to be clear, yeah, what my point about the bonds were, don't worry that then when he finally loses, I put it in too short of a hand, he won't pay. Don't worry about it. He has 30 days to pay after all appeals are exhausted, including at the U.S. Supreme Court. Meaning, if they don't take the case, and that I think that's 50-50, they're like, yeah, no. If they don't grant cert and reject it, it's over. There's nowhere else to go. And if that happens, 30 days later, he either pays her or she runs to the surety company, the bonding company, and says, okay, the debtor the judgment debtor didn't pay me, pay up. And they have to pay up. And the money, the other money, the $5.5 million, is sitting earning interest at the statutory rate in the court registry. So, she's one step, every time she wins the Second Circuit, she's one step closer. Now, of course, that one step, talking about crevice risk, is the United States Supreme Court. But she's got a phenomenal lawyer in Robbie Kaplan, who's, when she's not, her day job is representing E Jean Carrol, but she also represents other people. She's involved with a lot of different cases where she successfully has beaten Donald Trump and the Trump administration. And she's one of the good guys. She's one of the courageous people that's out there fighting for justice. Welcome back. We sit at the intersection of law and politics so you don't have to. We do it on a podcast that we call Legal AF. And if you didn't know why we call it that, well, now you do. It's every Wednesday and Saturday at 8 p.m. Eastern Time on the Midas Touch Network. And then we do these clips so that we can continue to grow our audience, try to get people as part of their journey to join our movement. And that's what I'm inviting you to do right now. Join Legal AF Wednesdays and Saturdays, 8 p.m. Eastern Time on the Midas Touch Network on audio podcast platforms of your choice. And then come on over to Legal AF, the YouTube channel, and hit the subscribe button there as well. So until my next report, I'm Michael Popok. Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.